case anyone's watching on YouTube. Okay. Hello, people watching us on YouTube. We will get started in just about 2 minutes here with our live stream, just waiting for everyone to sort of roll in. So give us about 2 minutes and we will get started. All right. Okay. I think he... All right, I think I'll get started. I think he's going to go first. Started. Okay, everyone, thank you so much for joining us for Right to Life of Central California. My name is John Girardi. I'm the Executive Director at Right to Life, and I want to welcome you all to our presentation on abortion law in the Biden era. This is kind of a replay in a, unfortunately, COVID socially distanced way of an event we did about 4 years ago after President Trump was elected. And I think we'll probably continue to do this every 4 years with a new presidential, and anytime a new president comes in. Basically, the point of this event is to kind of give us a little bit of a look at the next 4 years and what we can expect from abortion law in this country, and also to learn a little bit more about the lawmaking process in the state of California and some of the things we might see in abortion law out of California. To do that, I've brought in, I'm going to be speaking, and I've brought in two guests to speak with us, Professor Michael New from the Catholic University of America and my friend Penny Harrington, who works with a lot of our allied groups in California on pro-life and other issues. So tonight's event, we're going to get started. Tonight's event is going to kick off with Professor Michael New. Professor New is a visiting assistant professor of political science and social research at the Catholic University of America in Washington, D.C. Professor New received his PhD and his master's degree in political science and statistics, respectively, both of those degrees from Stanford University. So let's try not to hold that against him. I'm a Notre Dame grad, so we play Stanford in football every year. So it's just my little personal bias there. Anyway. Yeah. So anyway, nevertheless, in spite of his Stanford connection, Professor New has done a lot of excellent research on behalf of the pro-life cause. He is a scholar with, among others, with the Charlotte Lozier Institute, which is one of the leading pro-life think tanks in the country. And he has been widely published in National Review and a whole bunch of other outlets. So it's my great pleasure to introduce Professor Michael New.
All right, great. So thanks for the kind introduction, and I spent 5 very happy years of my life as a grad student at Stanford. So I did some pro-life work when I was there. My studies kept me pretty busy. This was before the West Coast Walk for Life. But one thing I was very proud of during my time at Stanford is we did actually collaborate with the students at UC Berkeley and did a pro-life conference my last year there. So we actually had a statewide collegiate pro-life conference in 2002. So it was nice to see Stanford and Cal folks actually working together for a bit. And they did the conference again in 2003. Actually, I came back for it, even though I'd left. So good to be back. I've enjoyed my time in California and pleased that John's invited me to give a presentation today. So I have a PowerPoint, and we're going to share the screen. And let's just hope everything goes according to plan here. Looks like you've disabled screen sharing, John.
We are enabling it right now, Professor.
Okay, great. Let's try again. I can share the screen. So here we are. Here's the screen share. And we'll go to the slideshow and start the show from the beginning. So here we're going to talk about the impact of the Biden administration. I've kind of lost my cursor here, but that's okay. On sanctity of life issues. So before I do, I want to kind of give a couple quick commercials about things I'm involved with. I met John a couple of years ago at something called the Vita Institute at Notre Dame. And I just want to encourage the attendees to think about applying to the Vita Institute. The Vita Institute is a week's worth of pro-life instruction. It's held every June on the Notre Dame campus. There are lectures and presentations on theology, philosophy, law, biology. I do either one presentation or 2 presentations on the social science. It's free of charge. If you get in, all you have to do is get yourself to South Bend. They put you up, they feed you, and you get to meet a great group of pro-lifers. You get to meet DC professionals. You get to meet people who've just graduated college. You get to meet nuns, seminarians, people working for various Respect Life ministries, people work for pregnancy help centers. So a great group of pro-life activists. So again, I can't recommend it enough. Applications are coming up soon. The due date's March 1st. There may be some wiggle room there, but I'd encourage everyone to apply. I think it's well worth your while. And I'm not just saying that because I'm on the faculty. I think John can testify what a good program it is. I also want to talk about the think tank that I'm affiliated with, the Charlotte Lozier Institute. For a long time, we really didn't have a dedicated pro-life research institute, that we had to rely on the Guttmacher Institute for data and analysis. And Guttmacher, up until about 2006 or 7, was the research arm of Planned Parenthood. So we're really not new anymore. In fact, we were launched around 2011, I think became public in 2012. So we're almost 10 years old, but still people should know about us, that we have a great team of scholars and researchers. We have experts in law, public health, social science. And again, we have research and commentary on pro-life issues almost every day. Give us a look on Facebook, follow us on Twitter. I think it'd be well worth your while. So I want to give a quick outline for the presentation. We're talking about sanctity of life issues in the Biden era. And there's several things that Joe Biden can do, and sadly probably will do, to undermine the sanctity of human life. He can do this through his executive branch appointees. He can do this through executive actions. He can do it through his legislative priorities. Outside the Biden administration, I want to give some other things we need to think about and be concerned about. But I also want to wrap up some good news, because I know that a lot of the presentation is going to be negative, but I always want to give people some reasons for hope and some reasons for optimism. So I will do that at the very end. So basically, I would say Joe Biden as president gets to appoint many people to the executive branch. That includes the cabinet. And the cabinet appointee that has the most power over sanctity of life issues is the Secretary of the Department for Health and Human Services. All right. HHS Secretary has a lot of power. One thing he does is HHS controls a lot of grant money for teen pregnancy prevention programs. And unfortunately, the Biden administration likely will steer that money to programs that encourage and emphasize contraception. They'll probably steer it away from programs that emphasize abstinence. Because of the Affordable Care Act, the HHS has a lot of power over health insurance. So I'll talk about that in a second. So this has, so this appointee has a great deal of power over public policy involving abortion and other issues pertaining to the sanctity of human life. Now, unfortunately, as you probably know, Joe Biden has nominated Javier Becerra to be HHS Secretary. Who is Javier Becerra? A couple things. He was a former congressman from California. Also, used to be the Attorney General of California. And I'll just say this. If you thought Kathleen Sebelius was bad during the Obama administration, I hate to say it, Becerra's probably going to be worse. I would say if you look at his track record, he's probably going to be much worse. Let me explain. very pro-abortion voting record. As a congressman, had a 100% voting record from NARAL, a 100% voting record from Planned Parenthood Action Fund, a 100% voting record from Planned Parenthood of California. As a matter of public policy, Javier Becerra supports tax-free funding of abortion. He opposed the partial birth abortion ban. He also opposes legislation that would protect infants born alive during botched abortions. So, very aggressive pro-abortion record. But that's not the worst of it. I think, no matter who Biden picked, it would probably be somebody who supported legal abortion. But here's what concerns me more than anything. As California Attorney General, Becerra really used his power to bully and intimidate and harass Christians and pro-lifers. He defended a California law that required that all insurance plans cover abortion on demand. I think even worse, he defended the law that required pro-life pregnancy help centers to violate their conscience rights and require them to provide clients with information about how to obtain an abortion. In California, you have great pregnancy help groups that help women in need. Becerra defended laws as Attorney General that required these groups to give information out about how to obtain an abortion. That's a real violation of their conscience rights. These people want to affirm human life. They don't want to encourage or even tell people about places that might terminate human life. Even worse, Becerra even sued the Little Sisters of the Poor. He insisted that they should be allowed to, he insisted that they be required to buy health insurance plans that pay for contraception and abortifacients. Again, another violation of their conscience rights. Little Sisters of the Poor doesn't want to be political. They want to serve the elderly. They want to serve especially the elderly who are low income. They don't want to spend time in litigation. But because of Javier Becerra, he wanted to make them pay for health insurance plans that covered contraception and abortifacients. And as a result, they had to devote scarce resources and scarce time to litigation. And it gets even worse. In 2016, I'm sure you heard, investigative journalists David Delight and Sandra Merritt provide video evidence, very compelling video evidence, that Planned Parenthood was engaged in the sale and trafficking of fetal body parts. And I would encourage everyone to look up these videos online. Even years later, it's still shocking. Now, Becerra was the Attorney General. Did he go after Planned Parenthood for their egregious and outrageous conduct? No. Instead, he pursued legal action against the journalists, Delight and Merritt. He charged them with 14 counts of illegal reporting and 1 count of conspiracy. And a move that even the LA Times, hardly a right-wing newspaper, called a disturbing outrage, their exact words. So, Becerra really is in the pocket of Planned Parenthood. Now, it's just tragic. We're in a global pandemic. So does Joe Biden nominate a health policy expert to serve as Secretary of HHS? No, basically he's a political favorite of Planned Parenthood. He nominates an abortion rights activist. So there have been some committee hearings on Becerra. There was a committee hearing, this week. A couple different, congressional committees held hearings on the nomination. I think the vote will be next week. We have been rallying. Democrats for Life had a rally in Washington, D.C. on Saturday. I was very pleased to speak at that. We're hoping that Joe Manchin does the right thing and votes against him. We're also trying to work on some of the other Republicans, like Lisa Murkowski, seem to drop some tea leaves that she might support this nomination. We need to find a way to stop him. If we don't, the hearings and the publicity has been good. Sunlight's the best disinfectant. But again, we need to work to his defeat, that we don't want someone like him chairing the Department of Health and Human Services. Now, Joe Biden also has a lot of control over what happens in the executive branch. There's a couple things he might do that might, again, undermine a culture, that might, undermine, culture of life. He might very likely will repeal the Respect Life rule. And he has already repealed the Mexico City policy. I'll talk about both of these in turn. So the Trump administration enacted the Protect Life rule in 2018. It limited the ability of entities that performed abortion to receive certain government grants. This money was redirected to health centers that don't perform abortions. And because of this, Planned Parenthood lost approximately $60 million a year in federal funding. So we didn't succeed in defunding Planned Parenthood, but we did make a dent in it. That the Trump administration did enact this Protect Life rule, and we should thank them and applaud them for that. The Biden administration will likely repeal this, and that will make Planned Parenthood and other entities that perform abortions able to get more government funding. So we need to keep an eye on that.
Hey, Michael, I don't want to interrupt your flow too much, but I just wanted to make one mention that I forgot at the start of your talk. In case any of you are interested in asking questions, in Zoom, there is a chat feature. And all of you who are participants, if you have any questions for Professor New or for any of the subsequent speakers during the talk, do feel free to ask your questions in the chat, and then we can select some of those. And at the end of Professor New's talk, we can ask him some of those questions. So I apologize, Professor New, I should have mentioned that at the start of the talk, but I just wanted to let everyone know that they had that opportunity. So anyway, carry on.
So another thing the Biden administration tragically has already done is reverse the Mexico City policy. And the Mexico City policy is something that every Republican presidential administration since Ronald Reagan has put in place. And what it does, it prevents U.S. federal aid dollars from going to non-governmental organizations, NGOs, that either promote or perform abortions. Again, this was put in place by President Reagan in 1984. It was also put in place by George H.W. Bush and George W. Bush. Trump administration, the Trump, like other Republican presidents, put the Mexico City policy back in place, and he also strengthened it. And he, expanded it so it kind of covered all international health care aid, totaling $9 billion. So Trump not only put it in place, Mexico City policy, he expanded it. And that was a good thing. We should applaud him and his administration for doing. That said, very shortly after taking office, the Biden administration reversed the Mexico City policy. So that means that, federal aid dollars, your taxpayer dollars, will go to NGOs that promote and perform abortions. So again, this means that our federal aid dollar, federal tax dollars will be going to overseas groups, either do abortions or promote them. So that's a real setback. What about legislation? Well, a couple of legislative priorities I want to talk about. One is the Equality Act, and another is a repeal of the Hyde Amendment. So the Equality Act, a lot of the coverage of the Equality Act deals with how it affects transgender Americans, and that's important. But I want to talk a little about sanctity of life issues, which I don't think got as much attention as it should have. The language of the Equality Act pretty clearly states that any refusal to do abortion is pregnancy discrimination. So what this means in practice is that this would jeopardize the conscience rights of doctors and other healthcare professionals who either don't wish to perform abortions or assist with abortions. That tragically, the United States, abortion has been legal in all 50 states since the Roe V Wade decision in 1973. And one thing I think we've done pretty well as a country, it's tragic abortion is legal. It's horrible that 60 million abortions have happened. But one thing I think we've done a pretty good job at, not perfect, pretty good, is we have been good about defending conscience rights. By and large, with a few exceptions, doctors and other healthcare professionals who don't perform abortions don't have to. The Equality Act jeopardizes all of this. So we might really see the conscience rights of Christian doctors or religious doctors be violated if the Equality Act comes to pass. So some would also argue, again, I'm not a lawyer, but I've seen some analysts argue that the Equality Act might not only violate the conscience rights of healthcare professionals, but it might also jeopardize the Hyde Amendment, and it might also jeopardize other kinds of protective pro-life laws we have, both the state and federal level. So tragically, the Equality Act did pass the U.S. House today. It passed by a 224 to 206 margin. It looked like every Democrat and 3 Republicans voted in favor. So it'll go to the Senate. I think this is something that the Senate will filibuster. I think we have a good chance to defeat the Equality Act in the U.S. Senate. But, senators need to hear from pro-lifers. We need to make it very clear that we don't want this bill passing. They should use the filibuster power against it. And again, we don't want the conscience rights of our healthcare professionals being violated. So that's an important priority. I would argue our top priority, that's important. This is very important too. Joe Biden wants to see the Hyde Amendment repealed. So I'll give you a little history of the Hyde Amendment. Again, Roe v. Wade was handed down by the Supreme Court in 1973. And in the initial going, pro-lifers realized that getting the Supreme Court to reverse this decision probably was not going to happen, in the short term. That said, pro-lifers, were strategic. They wanted to do something tangible to lower the abortion rate and protect the conscience rights of taxpayers. And one strategy they pursued successfully was the Hyde Amendment. So the Hyde Amendment is a rider to the annual appropriations bill that funds the Department of Health and Human Services and the Department of Labor. And what the Hyde Amendment does is it limits the ability of the federal government to use tax dollars to pay for abortions through the Medicaid program. Now, it's not a ban on funding of abortion through Medicaid, but it is a pretty tight limit. that only abortions in a handful of somewhat unusual circumstances can be funded by the federal government through Medicaid. So it's a pretty tight limit and does prevent a lot of taxpayer funding from funding abortion. The Hyde Amendment has been passed every year since 1976, and it was, again, a big political victory for pro-lifers. And one thing I should have included, it was also an important kind of legal victory for pro-lifers, that after it was passed, there was a lot of litigation, that cases involving the Hyde Amendment kind of worked their way through the courts in the 1970s. In 1980, Supreme Court agreed to hear a case involving the Hyde Amendment. And in 1980, in a case called Harris v. McRae, the Supreme Court ruled and upheld the Hyde Amendment. They agreed that abortion, was legal, but they said that even though it's legal, taxpayers don't have to pay for it with their taxpayer dollars. So the Hyde Amendment was upheld by the Supreme Court in 1980, the Harris v. McRae decision. And interestingly, the U.S. abortion rates fallen just about every year since that time. So it was a big political victory for pro-lifers and a big kind of judicial victory as well. Now, the Hyde Amendment used to be bipartisan. When it passed, it used to get a lot of votes from both Democrats and Republicans. In fact, 107 House Democrats voted for the original Hyde Amendment in 1976. When they were president, neither President Clinton or President Obama really came out in favor of it, but both presidents agreed to sign appropriations bills that contained the Hyde Amendment. So you had two Democratic presidents signing appropriations bills that contained Hyde protections. As a U.S. Senator, Joe Biden supported the Hyde Amendment. He had the position of a lot of Democrats in the House and Senate. They thought abortion should be legal, but not paid for with federal taxpayer dollars. So Joe Biden, as a U.S. Senator, he supported the Hyde Amendment. That said, as you're probably aware, the Democratic Party has shifted to the left on sanctity of life issues. And that has really jeopardized the Hyde Amendment. At least 180 House Democrats are on record opposing Hyde, probably more than that. That's just the count I came up with, which is an old count from 2 years ago. It's probably more than that. And when running for president during the summer of 2019, Joe Biden changed his position on the Hyde Amendment. After literally decades of supporting the Hyde Amendment as a U.S. Senator from Delaware, around the summer of 2019, he changed his mind, and now he opposes the Hyde Amendment. So again, Joe Biden thinks that not only should abortion be legal, it should be paid for with federal taxpayer dollars. Now, the Hyde Amendment has been very powerful for pro-lifers. That I think that one thing I've done a lot of research on is the impact of different kinds of pro-life laws. And a lot of the laws we pass do some incremental good, and I think the incremental strategy is very wise. But I would say the best thing we've done legislatively is getting taxpayer dollars out of abortion. Almost everyone agrees. Pro-life researchers, quote-unquote pro-choice researchers, is once you quit funding abortion with taxpayer dollars, abortion rates go down and lives are saved. It's basic economics. If abortion is quote-unquote free or heavily subsidized, abortion rates go up. If women have to pay for abortions out of pocket, abortion rates go down. So in 2009, the Guttmacher Institute, again, this up until 2006 or 7, was Planned Parenthood's research arm. They published a literature review which looked at the impact of Medicaid funding of abortion. And again, Guttmacher really tends to downplay the impact of pro-life laws. They always argue, I think incorrectly, that more contraception is the best strategy to get abortion numbers down. But the research is just overwhelming here. I mean, a vast majority of studies they found show that if you limit taxpayer funding of abortions through Medicaid, abortion rates go down and lives are saved. So even though Guttmacher tries to play down the impact of pro-life laws, even they agreed with their literature review that if you cut off taxpayer funding of abortion through Medicaid, abortion rates go down and lives are saved. So the Center for Reproductive Rights did analysis of the Hyde Amendment in 2010. Again, this is obviously a group that supports legal abortion. They found it saved 1 million lives. I did a study for the Legislature in 2016 on the 40th anniversary of the Hyde Amendment. I updated my findings last year, 2020. I found the Hyde Amendment saved over 2.4 million lives. It continues to save over 60,000 lives a year. So please, don't anyone tell you that pro-life political involvement has been for naught. There are literally 2 million people walking around today who owe their lives to the Hyde Amendment. So this has to be a top priority for us. We really need to go to the mat to defend the Hyde Amendment. So again, it's not going to be easy. Democrats control both the House and Senate. They have majorities in both chambers. That said, their majorities are slim. And, there are people, potentially, again, it's not going to be easy. But, the one pivotal vote in the Senate is Joe Manchin, who represents West Virginia in the U.S. Senate. West Virginia is a very pro-life state. Most of Joe Manchin's constituents are pro-life. Joe Manchin does vote pro-life sometimes. He might be persuadable. There might be other Democrats representing red states or quote unquote purple states or red districts or purple districts that we can work on. So their margins are slim. We don't need to flip that many Democrats. So again, the Hyde Amendment, it's not a done deal. I think it can be protected. It can be preserved, but this will require our best effort. And I think we need to, again, invest time, effort, energy, doing what we can to defend the Hyde Amendment. It should be our top priority. I'm not exaggerating. I say tens of thousands. By my calculation, 60,000 innocent human lives are at stake. So this really needs to be a top priority for pro-lifers this year. Now, I've talked a lot about the Biden administration, and I don't mean to keep giving you bad news, but there's more bad news. So we have some other reasons to be concerned about. Joe Biden's bad enough, but there's other things we should be concerned about. One thing we should be aware of is that there's efforts to weaken or repeal pro-life laws in blue states. And we've seen an increase in chemical abortions lately. And that's something that we need to think about and be aware of and try to counter. So again, Democratic Party shifts to the left on sanctity of life issues. You see many states repealing or weakening existing pro-life laws. So in 2017, Governor Rauner, who unfortunately doesn't matter what party he is, but he was a Republican, but a quote-unquote pro-choice Republican. He signed legislation requiring the Illinois state Medicaid program cover elective abortions. We already have data from Illinois that taxpayer-funded abortions went way up in Illinois once this piece of legislation was signed, once it went into effect. 2019, Maine did the same thing. Maine started requiring that their state Medicaid program cover elective abortions. I don't think we have data from there yet, but I'm sure Medicaid-funded abortions went up in Maine. I'm pretty sure that overall abortions went up in both these states. So we see Illinois and Maine changing their policy and requiring that their state Medicaid program pay for and cover elective abortions. Not too long ago, the Roe Act in Massachusetts was passed over the governor's veto. That weakened the state parental involvement law. Massachusetts actually was one of the first states to have a pro-life parental involvement law. Their pro-life parental involvement law took effect in 1981. It's been around for a long time. It's protecting tens of thousands of minor girls and their unborn children. Now, because the parental involvement law is weakened, that now means that 16 and 17-year-old girls in Massachusetts, again, 16 and 17-year-old girls can now get abortions without their parents' consent. So that's certainly bad news out of Massachusetts. So this trend will continue in 2021. There are efforts in Illinois to repeal their state's pro-life parental involvement law. There's also efforts underway in New Jersey to pass a legalized abortions throughout all 9 months of pregnancy and even make it possible for non-physicians to do abortions. So a lot of blue states, sadly, are very active trying to make abortion policy more permissive. This is something we need to be aware of. We also see an increase in chemical abortions. The RU46 abortion pill was approved by the FDA in 2000. Unfortunately, this is an administrative decision. There was no hearings. There was no testimony. There were no people from other countries who came to discuss their experience with RU46. So this was just done, by the FDA. Again, no hearings, no testimony, no legislation. Chemical abortions have increased pretty steadily since 2000, but the increase in chemical abortions has become a lot more dramatic in recent years. Between 2015, 2018, there's a slight mistake on this, I apologize, but the percentage of all abortions that were chemical abortions went from 25%, that should be not $40, 40%. So again, the percentage of all abortions that were chemical abortions went from 25% to 40%. In 2018 alone, the number of chemical abortions in the U.S. increased by more than 10%. So for the 2018, for the first time in a long time, the U.S. abortion rate went up. And having looked at the data, I think this big increase in chemical abortions is a reason why. We've seen a pretty consistent downward trajectory in the U.S. abortion rate, but we saw a slight uptick in 2018. And I think this increase in chemical abortions is an important reason why. Now, supporters of legal abortion are trying to increase the availability of chemical abortions. They've been trying to do this during the pandemic. They're going to keep trying to do this after the pandemic's over. So we see several things they've done. 2016, the FDA changed its labeling. So now abortion pills can be taken later in pregnancy with fewer visits to the doctor. Our opponents are trying to make chemical abortions available through telehealth, where there's no face-to-face interaction with a physician. And they're trying to make chemical abortions available over the counter, where women don't have to have any interaction with a physician. This, is horrible. I mean, chemical abortions are obviously fatal to the unborn child, but they also pose health risks to women. We know from data from California's Medicaid program, that chemical abortions have a much higher complication rate. I think their complication rate is 4 times higher than surgical abortions. And if there's less medical oversight, it'll get even worse. If a woman has an undiagnosed ectopic pregnancy, a chemical abortion can be fatal. So making chemical abortions more available is certainly, will destroy a lot more unborn children, but also undermine women's health as well. So we need to be aware of this. Now, I've given you a bunch of bad news. Let's talk about some good news. I always like to give people some encouragement. So you want some good news? Here comes some good news. Pro-life movement has not succeeded overturning Roe v. Wade, but I think we've been more effective than people realize, even more effective than even some pro-lifers realize. We've got the abortion rate down by over 50% in 1980. The abortion rate today is probably lower than it was in 1973 when Roe v. Wade was decided. So this should get more attention than it realized. And, usually when there's public policy success stories like declining crime rates or the fall of communism, this gets some more attention. But here we've cut the abortion rate in half, and outside a handful of people with a real interest in abortion trends, this gets very little attention. So I think this is a big public policy success story. That a woman of childbearing age walking around today, she's half as likely to have had an abortion in a given year than her counterpart was some 40 years ago. So again, we've got the abortion rate down by half. That's great news. Again, we still have over 800,000 abortions every year. That's 800,000 too many. We have made progress. You can see the progress on this chart that after Roe v. Wade, the abortion rate goes up. It shoots up pretty dramatically. But after 1980, there's a couple of hiccups here and there, but it's gone down pretty steadily. This is data from Guttmacher. You see a pretty consistent downward trajectory in the abortion rate. And why do we see this long-term decline? Well, one reason, an important reason, and this should get more attention, is that a small percentage of unintended pregnancies result in an abortion. So we see that over half of all unintended pregnancies were aborted in 1994. They fell to 47% by 2000, fell to 40% by 2008. And a friend of mine here at CUA has preliminary data. The percentage may be as low as 29% in 2014. So more and more women are choosing life. So again, I just want to leave that statistic up. And I tell this to every pro-life audience that will let me talk. Fewer women with unplanned pregnancies are choosing abortion. Why do I tell pro-life audiences this statistic? Why do I present this to pro-life audiences? Because it shows our efforts are effective. If more women are choosing life and more unintended pregnancies are being carried to term, it all flows back to the efforts of pro-lifers. We're doing either one of three things. We're either changing hearts and minds and persuading women to, carry those pregnancies to term. We're providing more assistance to women through our pregnancy help centers. And we've seen an increase in the number of pregnancy help centers since the late 1980s. I think the amount has gone up by like 80%. So there's a lot more resources available for women who do face unintended pregnancies, or enacting pro-life laws. So if more women are carrying pregnancies to term, it's either because we're changing hearts and minds, or we're offering more and better services to them, or we're passing protective pro-life laws. So all of this traces back to the activities of pro-lifers. So it's not that unintended pregnancies aren't happening. It's when they do happen, women are choosing life. They're choosing life because of the good effort and good work of pro-life people like you and me. So some final thoughts. Even during hostile presidential administrations, pro-lifers have found ways to make progress. So, it's obviously difficult to have a president who's not pro-life, and they can do a lot from a policy perspective to undermine our efforts. But we did find ways to make progress under the Clinton administration, and we found ways to make progress during the Obama administration. We did a lot at the state level, that we took advantage of Supreme Court decisions to pass more protective laws, because President Trump has appointed Brett Kavanaugh and Neil Gorsuch and Amy Coney Barrett to the Supreme Court. A lot of these state level laws may get a more favorable hearing. I think that, I can't predict with certain what laws that the Supreme Court will decide to hear or how they'll rule. But I do think some of these protective laws will get a more favorable hearing, and we'll see states doing a lot more to protect the unborn. So that's reason for hope. And I know you live in California. I know that's a blue state. I know that limits what you can do legislatively, but no matter where you are, there's always things you can do to build a culture of life. People can sidewalk counsel. People can pray. People can support pro-life educational efforts. I think Students Life does a great job trying to promote a pro-life message and give out good pro-life materials to college students. We can always help pregnancy help centers. They're doing great work, often on a shoestring, trying to help women in need. So there's always things you can do to build a culture of life, even if legislation is not feasible because of where one might live. So one thing I always tell pro-life audiences: we're never promised a winning streak. We're never promised a smooth trajectory to victory. There will be defeats and there will be setbacks, but it's important to stay the course. And our cause is important. Unborn children are counting on us. Even though it may be frustrating, staying the course is more important now than ever. So suppose, you had a long day. And suppose that you were distracted and you weren't paying much attention to anything I was saying. That's fine. I've been there. If you forgot everything I said, just remember this one last slide. We have made progress. Since the 1973 Roe v. Wade decision, pro-lifers worked tirelessly to defend unborn children. In some cases, progress has not come as quickly as we would like, but progress has been made. I'm very confident we stay the course. Victory will someday be ours. So I appreciate your attention. And I want to show you one last thing. I help run the DC 40 Days for Life campaign. We just had our rally. Sister Dee Dee Byrne. This is our group photo. They're in the center with the blue hat. We had over 50 people. That's not everybody. We had 50 people attend this rally. When I came to Washington, D.C., I took a trip to the Planned Parenthood one Saturday. I saw like 2 pro-life people getting hammered on by like 6 abortion clinic escorts. And look at us. We've got 20, 30, 40, 50 people there on Saturday and no clinic escort. So we just built incrementally. I kept showing up on a Saturday morning and eventually folks joined me. So we were able to have a much better presence in front of the DC Planned Parenthood because a few people just agreed to keep showing up every Saturday. And it's made a big difference. We've reached out to a lot of people, given good information to a lot of people. Lives are saved on the sidewalk by prayerful pro-lifers. So it can be done anywhere, even in a liberal city like Washington, D.C. So if I can be of service to any of you in your pro-life work, you can email me. My email address is michael.j.new@gmail. John can tell you to get a hold of me. Follow me on Twitter. I tweet out pro-life commentary almost every day. So follow me on Twitter, Michael_J_new. Friend me on Facebook if you know John. We'll have at least one Facebook friend in common. I post my articles and essays there. So thank you for your attention. I don't know if John wants me to take questions now or if we want to wait for the next speaker, but thank you for your attention and best luck with your work.
Well, thank you, Michael. That was great. That was super great. So we've got a couple of questions that I'll pose to you. I think some of the questions will be answered in subsequent talks, so I won't get to those. And some of them are a bit repetitive, so but anyway, let me give you a few of these. The first question from Molly Kanufke. Hi, Molly. Is whether for a lot of this information, obviously a lot of this is kind of detailed. Is there a single spot where we could get some of this information? Obviously, anyone watching this, we can watch this subsequently in a YouTube format. But if you have any specific place, I don't know if you have any specific place where you'd be hosting some of this information or anything.
If you want this, you can email me. I'd be happy to mail you the PowerPoint slides. I would just say don't share them with like everybody, but you can use them for your own personal use. So if you want the PowerPoint slides, just email me. I'll send the PowerPoint slides to John, and let John circulate them however he sees fit.
Sure.
I assembled this just because I've been doing. Well, you're never bored in the pro-life movement, but I'm doing a lot of writing and speaking lately, and I've just assembled all this information from my own background. There's not any one source, but if you want the slides, I'm happy to mail them to you.
Okay, great. The next question I'm going to do really quickly. One interesting question I saw was a question about policies like parental leave for pregnant women and other kind of child care benefits and things like that. Obviously, these things, I think some people might disagree with them or agree with them on fiscal grounds. In and of themselves, they're all very nice. They're all very good things. I just wanted to ask if in your research, Professor New, you had found any kind of discernible impact on abortion rates from different policies, whether it's change in pregnancy, paid leave during pregnancy, child care benefits, things like that on the abortion rate, or if we're even able to discern what the impact of those kinds of policies are.
You asked a very probing question, and I think we need more research on this. And I know that's kind of a dodge, but it is an honest answer. There's not much research suggesting, or really any research I've seen suggesting that, say, expanding welfare benefits gets abortion numbers down. That I know some women do seek abortion for financial reasons. But by and large, people have analyzed the, differences in welfare benefits across states and holding factors constant. It just doesn't seem that the generosity of welfare benefits really seems to have all that much impact. And there is some interesting research, I think out of Eastern Europe. I think it was Romania changed their policy to really have better kind of family leave policies in place. I think Hungary is doing some things with family leave, really kind of encouraging women to carry pregnancies to term. There is some evidence there that some of these family leave policies, might discourage abortion and encourage women to carry pregnancies to term. Just because something works in another country doesn't necessarily mean it would work in the U.S., but I think that's something that we should, look into, having more kind of family-friendly policies, do what we can to support women who do want to carry pregnancies to term. Again, I don't think it's a substitute for pro-life laws. I think that needs to be abundantly clear. Unborn children deserve legal protection. I think that has to be our top priority. But if there's things that we can do, policy tools we can use to help women who want to carry pregnancies to term, I think we should explore that. And I'm open to research that would look at this further. I just don't think we have enough research to say for certain what would happen if these things are put in place in the U.S.
Okay, well that's a good answer. The last question I'm going to give. I know Professor New, you do a lot of stuff with Democrats for Life of America, and we had a question about how you see their role within the Democratic Party and as maybe being kind of a leaven within the party, what their effectiveness has been, and if it's kind of whether from your perspective, just because I know you and I are both friends with Teresa Bukovac, who is heavily involved with them out of San Francisco. She runs Pro-Life San Francisco. And I just wanted to ask if you had any thoughts about the role of Democrats for Life.
Well, I think the Democrats for Life deserves our support. They certainly have their work cut out for them. The Planned Parenthood and groups support legal abortion, plow a lot of money in the Democratic Party and a lot of Democratic candidates. But what they do is very important. I mean, a lot of times you get situations like what we have now where congressional margins are very slim. And if they can succeed in getting, even a small number of pro-life Democrats elected to either the House or Senate, they can be pivotal. So one thing I've always said is that, my long-term goal, I think we need two pro-life parties competing with each other to see who can do the most to protect the unborn. That's a goal that's probably going to be a long time in coming, but that's the ultimate goal, I think. So I think that their efforts deserve support. I don't really know what the best strategy is. I think they're trying different things is good. I think that working the local level might make sense. If they can just get a farm team of good pro-life Democrats like to the state legislature or even city council, those are your future congressmen and future senators tomorrow. I think that could work. I also think getting a well-known Democrat to run for president on a pro-life platform could be useful. I think that candidate would do a lot better than people think. I just found it amazing that we had some 20-odd Democrats running for president in 2020, and none of them were really doing much of anything on sanctity of life issues. We couldn't get any of them to jump on stage and support the Hyde Amendment. And it's interesting. I mean, you're not going to break out of the pack by doing what everybody else is doing. You might break out of the pack and do something different. And I thought some Democrat, maybe Tulsi Gabbard, maybe somebody else should jump up and say, hey, I oppose tax-free funding of abortion. They probably would have gained some votes that way. I mean, they would have gotten criticized by the other candidates, but it would have, separated them from the rest of the field. So, they have their work cut out for them. But I think that, again, you've a lot of pro-lifers there who have liberal political views on other issues. I think they're a constituency that nobody really represents very well right now. And if Democrats for Life can organize pro-life Democrats, succeed in getting some people elected, whether it be to state offices, local offices, or federal offices, their efforts should be applauded. So I'm looking forward to working with Teresa and working with others involved with Democrats for Life.
Okay. All right. Well, thank you, Professor New. I know everyone's muted, but I encourage everyone to give you a stirring round of applause for a great talk. And thank you so much for joining us.
Thank you.
We're now going to turn for the second part of our program. I'm going to be speaking. So, and then we'll round things off at the end by talking with Penny Harrington, who's going to talk with us about California state issues. So I'm going to ask my producer, Raphael, to pull up my PowerPoint here. And hopefully we'll get into presentation mode there. And all right, so here we go. Okay, folks, so my name is John Girardi, and I'm the director at Right to Life of Central California. I'm also an attorney, and I'm a graduate of Notre Dame Law School. And when I was at Notre Dame, I tried to tailor my legal education. I always had an interest in the topic of abortion and was a pro-lifer. I'm the first Right to Life baby to be director of Right to Life, as in I was going to Right to Life events when I was a kid, and now I'm the director. So anyway, in some ways, my interest in this movement is a fruit of a lot of you and your support of Right to Life of Central California. So I want to talk about, Professor New talked about what could happen with abortion from the perspective of legislation and executive actions. And what I want to talk about today is what could change with abortion in the courts. In the 2020 election, we had a pro-choice president elected and a pro-choice majority in the Senate elected, but the Supreme Court doesn't change because the president changes. And President Trump's 3 new Supreme Court picks have really shifted kind of the balance of ideological power on the court. And I want to talk real quickly about what we could see over the next 4 years. So first, I want to talk about the legal context. Most of American abortion law is the result of Supreme Court decisions that interpret the Constitution. Okay, Supreme Court decisions that purport to interpret the Constitution. So to explain this, I thought I'd give kind of a hypothetical example here. So imagine, if you will, that the state of California passes a law, and it says that no one is allowed to be a Presbyterian. The Presbyterian church is illegal, okay? Now, if you're a Presbyterian, what do? Well, you get together with your fellow Presbyterians and you file a lawsuit. You file a lawsuit against the state of California, and you say, the state of California, it has passed an unconstitutional law. They are infringing our constitutional right under the First Amendment to free exercise of religion. And what the court will do is the court will review the petition, and they'll say, yes, you're right. The state of California is violating your constitutional rights. So by the authority of the court, we strike down this California law as unconstitutional. We say it's null and void, unenforceable. Okay. Now, that's a pretty easy example, but it illustrates a couple of things. All right. First, the role of normal laws as they apply to the Constitution. Okay. Normal laws, thousands and thousands of normal laws are passed all over the country every single year. The U.S. Congress passes gazillions of laws every year, and you all know how that works. Any of you who've seen Schoolhouse Rock, a majority in the House of Representatives, a majority in the Senate, and the president signs it, boom, you have a law. Okay, in the California state legislature, it's a very similar process. A majority in the California Assembly votes on something, a majority in the California State Senate votes on it, and then the governor signs it into office. So it's a very analogous structure. And thousands of these laws are passed every year. Laws passed by Congress in Washington, D.C. that apply to the whole country, and laws passed in the individual state legislatures. And all of these have to be consistent with the United States Constitution. The Constitution is kind of like our super law. It's our foundational law that basically it contains the most important structures of our government. It contains some of the most important individual rights we have as Americans. And as a result, you can't just pass a normal law that contradicts it, okay? The right to freedom of speech wouldn't mean much if, the minute the Democrats are in the majority, they can just pass a normal law saying Republicans no longer have the right to freedom of speech, okay? The Constitution is structured in large part to protect the rights of political minorities. Now, the other thing to notice from our example is that our poor Presbyterians, whose church was made illegal, they went to the courts for relief, all right? And the role of the courts, the role that the courts have taken on in this country is to basically apply, in an individual case or controversy, apply the Constitution, apply the relevant law to that case and controversy. Now, the example I gave was pretty easy, okay? California was trying to make the Presbyterian church illegal. So let me give you a more difficult constitutional question. And this illustrates that the Constitution doesn't always interpret itself, okay? Let's look at the Second Amendment. Second Amendment protects the right to keep and bear arms. Now, I think most of us would agree that the right to keep and bear arms extends to, being able to own a knife, but it probably doesn't extend to being able to own, a small nuclear warhead in your backyard, okay? So somewhere along that spectrum is what you can do, okay? Let's suppose the state of California tries to ban semi-automatic weapons, okay? Now, this is more of a disputed question. Gun owners would get together and sue the state of California saying, hey, this violates our right under the Second Amendment. Let's suppose you start at the federal district court. Let's say the federal district court gives one ruling saying, okay, we think we, the federal district court, we think that the Constitution means X, and as it applies to this law, California is not allowed to ban semi-automatic weapons. Then that gets appealed to the Ninth Circuit Court of Appeals. That's the federal circuit court that hears appeals from federal cases in California. The Ninth Circuit Court of Appeals disagrees with that prior decision. It gets appealed up to the Supreme Court. And finally, at the Supreme Court, the U.S. Supreme Court says, we interpret the Constitution as meaning that California cannot ban the sale of semi-automatic weapons. The Second Amendment right to keep and bear arms extends to individuals being able to own semi-automatic weapons. Now, you might think the Supreme Court is right. You might think the Supreme Court is wrong. But the Supreme Court's ruling is the law of the land, okay? They're the final authority that you can appeal to. There's no one above the Supreme Court, okay? They're authoritative because they're final. They're not final because they're authoritative, okay? They're the last court you can appeal to. So, and if they say that the Constitution means you can't ban semi-automatic weapons, that is, for all practical intents and purposes, what the Constitution means. Other states can't then join in and try to ban semi-automatic weapons, all right? Because the Supreme Court has spoken. So this is an important thing to understand. Sometimes people will ask me, well, why can't we just pass a law to outlaw abortion? Well, we can't pass a law to outlaw abortion because Supreme Court decisions have ruled that the Constitution itself protects the right to abortion. So if the Constitution states that, then no, you can't just pass a normal law. It would be like trying to pass a law outlawing Presbyterianism, unfortunately. Now, you may ask, well, what if the Supreme Court gets it wrong? What's our remedy? So you only have 2 and maybe 3 remedies. The maybe third remedy is the remedy that Andrew Jackson utilized. When Andrew Jackson was president, there was an adverse opinion against him that the Supreme Court issued, and Andrew Jackson just ignored the Supreme Court. And he said, well, if the Supreme Court issued their decision, let them enforce it. Because ultimately, the president, the executive, is the one who has to enforce the law. Now, that's kind of a risky proposition. That's kind of a dangerous precedent in some cases. If you have a totally crazy president, as Andrew Jackson was at some points, that can be not a great thing. So I only say that's half of a solution. Your 2 more legal solutions are either to pass a constitutional amendment. So the Supreme Court interprets the Constitution a certain way. You think they're incorrect. What you can do is pass a constitutional amendment, kind of force the Supreme Court's hand, force them to interpret it the way you want it by making it explicitly clear in the Constitution what you want it to say. Constitutional amendments are really hard, all right? They require 2/3 votes in both houses of Congress. They require 3/4 of the state legislatures. It's really hard to amend the Constitution. Your other option is to wait for Supreme Court justices to die or to retire, and then elect a president who will nominate and a Senate who will confirm justices who think more like you do. And this pro-lifers have tried the strategy of a constitutional amendment. The Respect Life Amendment had been batted around throughout the 80s, never really got off the ground. But pro-lifers have been trying the strategy of let's elect presidents, let's elect senators who will nominate and confirm good Supreme Court justices who will overturn Roe v. Wade. That's the strategy we've taken. So that's, and just so people can understand why it is that you can't just, quote, pass a law to make abortion illegal. We're dealing with bad Supreme Court decisions. So let me talk real quickly about the biggie Supreme Court decisions, just so we have an understanding of them. I'm going to try not to get too bogged down in these, but let's get started. So the granddaddy of them all is Roe v. Wade. Roe v. Wade was issued in 1973, and it said that there is a fundamental right to legal abortion. Women have a fundamental right to legal abortion, and that it emanates from the Due Process Clause of the 14th Amendment. The 14th Amendment says, in this relevant part, nor shall any state deprive any person of life, liberty, or property without due process of law. Now, you may be scratching your head. How do you get abortion out of that? That's a good question. The theory is that in order for due process, fair legal proceedings, a fair legal system to exist in American society, certain rights have to exist and certain rights have to be protected. One of these is allegedly a right to privacy. Now, this right was kind of discovered in an earlier Supreme Court case from the 60s called Griswold v. Connecticut. The Supreme Court in Roe in 1973 thought that within that right to privacy was also a right to make certain kinds of private, medical, and familial decisions, such as the right to have an abortion. So they are implying a right to abortion within an implied right to privacy, which is implied out of the Due Process Clause of the 14th Amendment. This, I think, is silly. If you look at the history of the 14th Amendment, just for context for all of you, the 14th Amendment was, along with the 13th and 15th Amendment, after the Civil War, the North required that if any of the Southern states wanted to come back into the Union, they had to ratify the 13th, 14th, and 15th Amendments. 13th Amendment outlawed slavery. 15th Amendment made the newly freed African slaves voters and citizens. And the 14th Amendment had a bunch of different protections. One of them was this due process clause. And I think sometimes we can read these constitutional passages and think it's just kind of, the hoity-toity language. But if you look at it carefully, what the North didn't want the South to do was to become states and then set up separate and unfair legal processes for Black people. So you see in the 14th Amendment, they say, nor shall any state deprive any person of life, meaning execute them for a capital crime, liberty, meaning throw them in jail, or property, meaning criminally fine them or civilly find them liable in a lawsuit, without due process of law, meaning you have to have fair legal proceedings. So this was always Antonin Scalia's big critique of the Roe decision. Was he said, look, this part of the Constitution is about protecting fair processes. It's not about creating new substantive rights. And different conservatives agree or disagree to a lesser extent, but I kind of agree with Justice Scalia on that point. Now, hidden within this right to abortion, which was hidden within a right to privacy, which was hidden within this procedural guarantee of the 14th Amendment, there was also hidden, allegedly, a trimester system of how to regulate abortion. And this really shows that the justices on the Supreme Court, they weren't really interpreting law. They were writing law. They were just writing what they thought was the best way to regulate abortion, and in their opinion. So what they said was states and the federal government could pass no laws restricting abortion in the first trimester. They could have some health restrictions to protect the mom in trimester 2. And they said that states or the federal government could ban abortion in the third trimester, except for pregnancies that threaten mom's health. And by doing this, they overturned every state law outlawing abortion. Most states in the Union, California was one of a few exceptions to this, but most states in the Union in 1973 had laws on the books outlawing abortion. And a lot of these had been passed around the time of the Civil War, around the time that the 14th Amendment was ratified. So the notion that the people who ratified the 14th Amendment would have thought it had anything to do with securing legal abortion is totally laughable. So, and this illustrates what I'm saying. You can't just pass a law to outlaw abortion. A Supreme Court decision interpreting the Constitution takes precedence over a normal law. All right, let's go to the next biggie, which is Doe v. Bolton. And this Supreme Court decision continues to be really relevant in ways that people don't quite understand. This is the companion case for Roe v. Wade. It was issued on the same day. And remember in Roe how it said in the third trimester, states or the federal government could ban abortion except for pregnancies that threaten the mother's health? Well, Doe v. Bolton defined what that means. What is that health exception that has to accompany any ban on late-term abortion? Now, they define health so broadly that you could drive a Mack truck through it, okay? Health includes mental or psychological health. It includes the mother's considerations of the mother's age, and it also includes familial health, which the court defined as like, I'm not ready to have this baby. or this would upset my family dynamic if I have this baby. And guess who decides if health is implicated? It's the abortion doctor. So, and a lot of abortion doctors have testified that every pregnancy implicates health according to this standard. And it does. Literally, this standard is so broad that there is no unintended pregnancy that wouldn't qualify under this health exception. So it's so, the rule, the exception is so broad that it really swallows the rule. And effectively what it means is that you can't really ban abortion in the third trimester because every pregnancy qualifies for the health exception. So Roe plus Doe resulted in a legal regime where abortion was legal in the United States, everywhere in the United States, for all 9 months of pregnancy and for any reason. Now, let's switch gears to the most, I would say, the most important abortion decision. This is the most important abortion decision because unlike Roe gets all the, sort of the fanfare because it started things off. But this is actually still the controlling Supreme Court, the chief controlling Supreme Court decision on abortion. It actually is, you should really think of it as the case that succeeded Roe v. Wade and kind of took its place as our controlling abortion law in America. And that is Planned Parenthood versus Casey. Now, in 1992, pro-lifers were very optimistic. 8 of the previous 9 Supreme Court nominees were nominated by Republican presidents. And a lot of pro-lifers thought, as a result of that, okay, this is it. We're going to overturn Roe. And it was not it. A lot of Republican appointees to the court who people thought were pro-life, like Anthony Kennedy, Sandra Day O'Connor, and David Souter, they all upheld legalized abortion. So let's explain what Planned Parenthood versus Casey did. It replaced Roe as the operative law of the land, and to this day, it remains our controlling legal framework for abortion. It moves us away from trimesters, and now what we have is a regime of pre- and post-viability. So we're not regulated according to the trimester system anymore. Now we look at viability, which is a very silly thing to look at. Viability, which means basically, can this baby survive outside the womb? If a baby can, then that baby is viable. Generally, viability is a function of lung development. So if your lungs are really developed, then you're viable. And I don't know about you, but I've never thought of, the lung as being the signature thing that defines someone as a human being. But apparently Justice Kennedy did. Also, viability is a shifting standard. It can shift depending on sex. It can shift depending on race. It can shift depending on poverty, how good your hospital is. If a baby's born at a top flight NICU like Valley Children's Hospital, their viability point is probably earlier than someone who isn't lucky enough to have the Valley Children's NICU nearby. So it's a very strange standard to have as sort of a defining line in American abortion law. Now, the rule is before viability, you can't ban abortion. And you can ban abortion after viability, but again, you need to have an exception for the mom's health, for pregnancies that implicate the mom's health. And the Doe versus Bolton standard for health remains. So this is the technical law on the books in California. And you'll hear people say, well, abortion after fetal viability is illegal in California. Okay, yeah, but there's that health exception, which again is broad enough to drive a Mack truck through. Literally every pregnancy implicates a mother's health. Justice Kennedy rooted the right to abortion, or what he called a liberty interest in abortion, which is sort of legalese, means it's not quite as important. He based it in the word liberty from the 14th Amendment Due Process Clause, and basically thought that liberty consists in the ability to make key life decisions, including for individual women deciding whether or not prenatal life was valuable. The question of when life begins, Justice Kennedy thought the ability to determine that was part of what liberty means, which is kind of a bizarre definition of liberty. I'm in this studio with my producer Raphael here. If I guess if I redefine when life begins for people named Raphael, I could run him over with my car in the parking lot after this is over. But I can't, obviously, that's ridiculous. My liberty does not include the right to define when Raphael does or does not have human value. So anyway, if you take Justice Kennedy's language to its logical conclusion, it's totally silly. Now, Planned Parenthood versus Casey, it's not as bad as Roe v. Wade because it did give us more ability to regulate some aspects of abortion. We are allowed, state governments can pass laws to require parental notification or consent for abortions by their minor children. States can impose certain kinds of informed consent provisions like ultrasound requirements, 24-hour waiting periods, etc. States can impose some health and safety requirements on abortion clinics, although this is also a disputed point. Now, there have been a couple of other cases that are also worth mentioning. I'll mention the two Carhart cases. This was about whether or not either state governments or Congress could ban partial birth abortion. In 2000, the court ruled that no, you can't ban partial birth abortion, which is a wild and extreme viewpoint. In 2007, the only thing that changed was Sandra Day O'Connor got replaced by Samuel Alito. In my opinion, the best thing George W. Bush ever did was nominate Samuel Alito to the court. And in Gonzalez v. Carhart, the Supreme Court upheld a law that Congress had passed in 2003 banning partial birth abortion. And this shows just how disputed, just how weird our abortion law is. Basically, Justice Kennedy said that in Planned Parenthood versus Casey, Justice Kennedy said that states and the federal government can pass certain restrictions on abortion as long as they don't unduly burden a woman's right to abortion. Well, what's an undue burden? Some of the court thought that a ban on partial birth abortion was an undue burden, and then 7 years later, they thought it wasn't. It's an odd standard, and it just seemed to be which side of the bed Justice Kennedy happened to roll out of bed on. The next two decisions I'm going to mention quickly, are Whole Woman's Health v. Hellerstedt from 2016. Should have put an apostrophe after the woman before the S there. And then June Medical Services v. Russo, just from this past summer, from 2020. And this is about whether state legislatures can impose certain kinds of health and safety requirements on abortion clinics, specifically admitting privileges. Basically, in Whole Woman's Health v. Hellerstedt, it was Texas. June Medical Services v. Russo, it was Louisiana, passed laws requiring abortion doctors to have admitting privileges at a hospital within a certain mile radius. I believe it was 30 miles. And the Supreme Court in 2016 said, no, this would result in too many abortion clinics in Texas closing, and the health benefits aren't that big. So it's an undue burden on women's right to abortion, so we strike it down. June Medical Services v. Russo was a much different Supreme Court. The 2016, this was right after Antonin Scalia had died. So it was Justice Kennedy, 4 liberals, and then it was only Roberts, Alito, and Thomas in the minority. June Medical Services v. Russo, that court had Neil Gorsuch and Brett Kavanaugh on it, and John Roberts kind of stabbed us in the back. He sort of flip-flopped from his own position in 2016 to not give the victory to Louisiana, but sort of, this is actually a very highly confused question, because he still rejected the opinion of the majority from Hellerstedt, but it's a very strange decision, and I think the court is going to have to give a more definitive answer to this question of whether or not states can impose health and safety regulations, even if it results in a bunch of abortion clinics closing. So now, to look at the future, I want to just talk about the current makeup of the Supreme Court. And a lot of this is my opinion. So don't take this to the bank as this is the absolute gospel truth. This is my opinion, and it's a decently informed opinion, and I don't think I'm too far out of the mainstream of most conservative legal thought when it comes to this. So you have Sam Alito and Clarence Thomas. Their viewpoint is, I think they would love to throw out the whole apparatus of Planned Parenthood versus Casey, Roe v. Wade, the whole shebang, find one good case to do that and throw the whole thing out and basically say states can regulate abortion however the heck they want. So all of these different state laws that have been passed recently, Alabama tried to pass a law to completely ban abortion. A bunch of states have passed heartbeat bans to ban abortion after 6 weeks of pregnancy when fetal heartbeat can be detected. Some states have passed laws to ban abortion at 20 weeks when fetal pain, when fetuses can experience pain. Sam Alito and Clarence Thomas will let states do whatever the heck they want, regulate abortion just like any other healthcare practice. Amy Coney Barrett, my former law school professor, proud to say, I think she is probably in the Sam Alito and Clarence Thomas camp, but I don't exactly know. She doesn't really have many cases about abortion. I know she is super duper pro-life personally, so I'm hopeful, but I don't exactly know. I think she's the most Scalia-like of any of the recent Trump appointees to the court. So I think she would probably lean towards the Alito and Thomas viewpoint, but I'm not 100% sure. Neil Gorsuch and Brett Kavanaugh, I think, are probably going to be more incrementalists. So let me explain what I mean by that. I think with Gorsuch and Kavanaugh, rather than getting one case to throw out the entire regime of Planned Parenthood versus Casey, I think what you could see with them is taking an individual abortion restriction and okaying it. So this state wants to regulate abortion clinics in this way. All right, we'll permit it. This state wants to ban abortions that are chosen to discriminate against a child diagnosed with Down syndrome or a child because of his race or sex. Okay, we'll permit that law and go step by step, one thing at a time, permitting a more and more permissive, allowing state governments and the federal government to pass more and more laws to protect life. So get rid of Planned Parenthood versus Casey, but not all in one swoop. Do it step by step. And that is sort of a result of their judicial temperament, maybe more so than whatever their personal commitments are to life. While Neil Gorsuch had one Supreme Court decision in the Bostock case that I thought was kind of disappointing, just personally, I will note that Neil Gorsuch actually literally wrote the book on why and how pro-lifers should oppose physician-assisted suicide. So that's just an interesting thing to note about Neil Gorsuch and why it gives me hope that he'll do good things with abortion cases. With John Roberts, who knows? John Roberts has been all over the map lately. I think John Roberts is very scared about the possibility that Democrats want to pack the Supreme Court, expand the number of seats on the Supreme Courts, and fill it for ideological purposes. And he seems to be deliberately issuing decisions so that the Supreme Court doesn't seem super conservative. So I don't know what John Roberts would do when it comes to an abortion case. Sonia Sotomayor, Elena Kagan, and Stephen Breyer, they're super reliable. We know exactly what they would do. They would keep and expand legal abortion. In fact, they don't even really like Planned Parenthood versus Casey. They think that the few restrictions that Planned Parenthood versus Casey allows, I think they would get rid of the ability to issue even those very moderate kinds of abortion restrictions. And like Justice Ginsburg, I think they would rather root abortion law in something other than Justice Kennedy's kind of bad reasoning from Planned Parenthood versus Casey. One thing to note is, and again, this is just me forecasting, I think it's highly likely that Stephen Breyer is going to resign prior to the 2022 elections. Justice Breyer is the oldest current member of the Supreme Court, and I think it's highly possible that the Democrats could lose their majority in the Senate in 2022. They barely have a majority as it is. So I think with Justice Breyer, if he's going to play this smart, my guess is that he will probably retire. My guess is that he will retire probably early in 2022, maybe around the end of the Supreme Court term in 2022, maybe June of 2022, especially if it looks like the Democrats are going to lose the Senate. Now, let's talk about what are the issues the court could decide over the next 4 years. These are the kinds of things that the court could decide. And with this new makeup of the court, I think it's possible that Roberts could rule with the majority in these decisions. And even if he doesn't, I mean, we still might have a 5-4 majority to rule the right way. Here are the kinds of things that the court could decide. There are a couple of questions, and these are all cases that are currently floating around in the federal courts. So the federal court system has 3 layers. You have district courts, which is the lowest level where things start out that hear trials. You have the federal circuit courts, the First Circuit, the Second Circuit, Third Circuit, et cetera, and the DC Circuit, which here appeals from the district courts. So they're sort of in the middle. And then there's the U.S. Supreme Court at the top. So all of these issues are currently being litigated in the lower federal courts. One is whether states can ban abortion providers from their state Medicaid programs. This is a highly disputed question. Different states, different pro-life states are basically trying to disqualify abortion providers from their state Medicaid programs, basically defund Planned Parenthood through the Medicaid program. Medicaid is Planned Parenthood's chief source of government funding. They get like $400 million a year through Medicaid reimbursements. And a lot of states are trying to disqualify Planned Parenthood as providers who are eligible to take Medicaid patients. Can states ban second trimester dilation and evacuation abortions? This has to do with questions of whether banning a certain kind of abortion procedure, in this case, a very horrible abortion procedure that I won't go into the details, but it's a very violent way of performing abortions. Basically, can states ban certain kinds of methods of performing abortions? And specifically, there are some states that have tried to pass bans on this specific kind of abortion. Next, do abortion providers themselves have standing to sue against abortion regulations? This is actually a pretty disputed question. A lot of times, a state will pass an abortion restriction, and instead of finding a pregnant woman who wants an abortion to be the plaintiff in the lawsuit, the person who files the lawsuit, they'll just get an abortion provider to do it. And that doesn't seem fair. So in order to file a lawsuit, you have to show that you have standing, that your rights are being infringed, that you are facing a damage. The right to abortion adheres in women. It doesn't adhere in abortion clinics. And what you see is all the time, anytime a state passes an abortion law, you'll get Planned Parenthood of whatever that state is filing the lawsuit. Well, we've just sort of glossed over that as if they're the people whose rights are hurt. And I don't know that that's clear. Justice Thomas has repeatedly argued that we shouldn't just assume that Planned Parenthood has standing to sue in all of these cases. The next question, can states ban abortions that are chosen for discriminatory reasons? Some states have passed laws like this, basically to say we outlaw any abortions that are chosen purely because of the child's sex, so no sex-selective abortions, because of the child's race. I had an affair with a person of a different race, and I don't want to have a baby of that race, or because of some kind of physical handicap. And chiefly what laws like this impact are, can you abort a child because he or she has Down syndrome? And to pass a law like this, it would ban abortions chosen purely because a child has Down syndrome. So can states ban abortion for these kinds of reasons? In many, many other areas of American law, sex, race, and physical handicaps are protected legal categories where people are not allowed to engage in discrimination. So can that apply to abortion? And then there are various states that have imposed limits on abortion that are really direct challenges to Planned Parenthood versus Casey. Some states have banned abortion at 20 weeks. Have tried to pass laws. By the way, all of these laws have been enjoined. So none of these laws are actually in force because, again, they conflict with Planned Parenthood versus Casey in a lot of ways. Now, can states ban abortion at 20 weeks when fetuses, a lot of researchers have concluded that fetuses can begin to feel pain at 20 weeks of pregnancy? Can states ban abortion at 6 weeks of pregnancy when fetal heartbeat can be detected? Can states just ban all abortions? That's what the state of Alabama did. Now, as I said, none of those laws have come into effect because they all put bans on abortion at a point before fetal viability. Again, fetal viability is around 22 weeks at the earliest. So these are all issues that are floating around in the federal courts, and eventually they're going to make it to the U.S. Supreme Court. And as I've been saying, I think we have a lot of reasons to be hopeful. The last thing I'm going to talk about is court packing. Court packing is this thing where you try to expand the number of seats on the Supreme Court in order to fill the court with people who you agree with people who are ideologically more like you. It's only been attempted once in American history. FDR in 1937, tried to add, he kept getting a bunch of 5-4 losses against various of his New Deal policies. So he tried to pass a law to add 6 new justices to the Supreme Court. didn't work out for him. The Democrats in the House and Senate, his own Democratic Party, which had huge majorities in the House and Senate, said, okay, you're going way too far here. But it did scare one of the justices on the Supreme Court who had been ruling against him all the time. He basically switched his votes and started ruling in favor of all the New Deal policies. This was called the switch in time that saved 9. Basically, he cowed the Supreme Court into doing what he wants. Now, Democrats have been threatening to pack the Supreme Court and the lower federal courts, and they can do that with a simple law. The number of justices on the Supreme Court is not set by the Constitution. So the majority in the House, majority in the Senate, and the president signs it, they can do it. But in the Senate has this internal rule called the filibuster. Basically, to advance a piece of legislation and end debate on legislation, in the Senate, debate can technically go on forever. To actually end debate and advance a law to a final vote, you actually need 60 votes to stop debate. So basically, you can talk any piece of legislation, almost any piece of legislation in the Senate to death. You can just talk it to death, and it can't go forward. So in order to pack the Supreme Court, really what the Democrats would need to do is abolish the Senate filibuster. And it's pretty clear that the Democrats don't have enough votes to do that. In addition to the 50 Republicans who don't want to do it, there are about 3 Democrats who say they don't want to get rid of the filibuster. Joe Manchin from West Virginia, Kristen Sinema from Arizona, and even our own Dianne Feinstein from California, surprisingly enough, I'm sure for many of you, does not want the Senate to abolish the filibuster and does not want to pack the Supreme Court. Democrats don't have the votes to do it, and I don't think they're going to gain the votes to do it in 2022. So those are kind of the that's my presentation. That's sort of the prospects for the next 4 years. To conclude, I just want to say one thing about John Roberts, which is sort of a hopeful thing. So one thing about Supreme Court decisions is that if you're the Chief Justice and you're in the majority, you get to pick who writes the decision. Okay. And that's a big way that the way that the Chief Justice can influence the outcome of Supreme Court decisions. If he's not in the majority, though, then the most senior justice in the majority is the one who picks who writes the decision. This, I think, is a reason why Justice Roberts could be incentivized to rule with the other Republican appointee justices. Justice Roberts so if Justice Roberts goes with the Democrat appointees on the court and rules against the other Republican appointees, that means that Clarence Thomas would be picking who gets to write the opinions. And I would love it if Clarence Thomas gets to write the opinions, because I think his viewpoint is probably the best out of all the members of the court. But I think John Roberts, if the court is going to start allowing states to pass more and more restrictive abortion laws, I think John Roberts is going to want to have some say over that process. So I do think we could see a number of 6-3 victories coming up on these abortion cases, and Justice Barrett's position on the court, replacing Ruth Bader Ginsburg, one of the most liberal justices, to replace her with one of the most conservative justices and possibly a very pro-life justice, was, I think, probably the single best pro-life accomplishment in the Trump presidency. So that's going to do it for my talk. I'm going to have my producer Raphael bring over some of the questions, and I'll see if I can answer some of these. And I appreciate all of your patience in waiting on me to get your questions loaded here. Hold on just one second, everybody. Did you text them to me, Ralph? No. Okay, so we have a couple of questions. All right. We have a great question from Louis Shapiro, who asks, what does codifying abortion law do? That's a great question. So one thing that Democrats have expressed as something they want to do, but again, it's a thing they can't really do unless they get rid of the filibuster rule in the Senate, is to pass a normal law putting in place all the provisions of Roe v. Wade. And this would do a lot of stuff. This would basically make this would basically then enshrine abortion in federal abortion law. It would override all of the different state laws that limit abortion, and it would almost make the country and overturn, Roe v. Wade repeal proof. Basically, the Supreme Court could repeal Roe v. Wade all they want, but that doesn't change anything because now we have a normal federal law on the books upholding legalized abortion. Now, again, I don't think the Democrats have the votes to do that, and they open themselves up to Republicans, if they ever get the majority again, just going right back and then codifying pro-life laws the other way. So that's a really good question by Louis Shapiro, and it's something to be really concerned about that the Democrats have wanted to do. I don't think they can actually accomplish it in the next 4 years, but it is a really big question. Next is a question from Cynthia Chambers. This is a very common question I get. How can a murder of a pregnant woman who wants to keep her child show two murders, one of the mother and one of the unborn child, but the murder of a woman who wants an abortion only be considered as one murder of the mother? This is a very common question I get about, for example, I think that was was that Connor's Law or Lacey's Law related to the Lacey Peterson case, where Scott Peterson, I believe, because of that case, now in California, you can charge someone for a double murder if they murder a pregnant woman. And so people say, well, we're acknowledging the humanity of the child in the context of murder cases and murder prosecutions, but we don't acknowledge the humanity of the child in other cases. How does that make sense? And my only answer is it doesn't make sense. And California law is bizarre and inconsistent, and it blatantly does not make sense. It seems like, we're eager to prosecute people for taking life, but we're not actually eager to defend that life in the normal context of abortion. So yeah, it just doesn't make sense. It really doesn't. I wish I had a better answer for it. But our law is fundamentally illogical and inconsistent on that point. So there's really no great answer. I've got a couple of other questions, but we are kind of running short on time, and I want to give Penny Harrington her ability to speak. So I really appreciate all the questions that everyone have given. I apologize if I can't get to all of them, but we do need to get Penny going here. So I'm now going to introduce our last speaker of the night, and I think a very interesting speaker because of her insight into California politics, which I think a lot of California voters don't even know a lot of these important issues of how the sausage is made in California politics. So to explain some of that for us and to explain some of the bad laws we might be looking at this year, I want to introduce Penny Harrington. Penny Harrington serves as a public policy analyst, assisting conservative organizations in tracking legislation and related issues. She has been passionate about making a difference in support of core conservative values and equipping others to do the same for more than 3 decades. Penny has served as the Director of Legislation for Concerned Women for America of California from 2001 to 2016, and she's currently part of the Biblical Citizenship Committee at her church. Penny also provides voter recommendations, Penny's Picks, for San Diego County, where she lives with her husband of 41 years. They are blessed with 2 grown sons, 2 wonderful daughters-in-law, and 2 beautiful grandchildren. So I'm pleased to welcome my friend, Penny Harrington. Penny, take it away.
Thank you, John. I really appreciate it. Because of the time frame, if you could just give me an idea, since we changed the order up a little bit, do you have a time that you wanted to stop tonight? I mean, this is pressing here.
No. You're good. You're good. So, yeah.
Okay. Well, I think I'm able to share my screen here. Let's give that a try.
I told everyone 30 minutes and knew it would be more like 40. So I think you're good to go with however much time you need. Okay. So go for it.
Okay, that's great. All right. So John stole my line with the sausage making, because that's kind of what it's like in California. I have this making law in the Golden State, and we're going to talk a little bit about the overview of the legislative process. And then we're going to focus on a few life bills that are pending this year. there may be more to come. Some of you have been involved in California politics perhaps for a while and know a lot about the procedure, and some maybe not. So I'm going to try to move through this rather rapidly. Make sure your seatbelts are fastened, your tray table's up, and everything's inside the car here, and let's go. The California Legislature is bicameral. It's made up of 40 senators, 80 assembly members, and you can see the breakdown of the parties here. And it also shows you that we obviously have a supermajority of Democrats in the state, and that drives a lot of the decision making, of course, in the state. So I'm wondering if each of you individually knows who your state senator and assembly member is in each situation, and I hope that you do. If you don't, this is a website that you can go to, findyourrep.legislature.ca.gov, and you can find out the legislator. There's a link to their website, their contact information. These are things that you're going to want to know when an issue comes up, to say, contact your legislator for because a committee hearing is coming up, or because there's a floor vote, or you just have something you want to share. I think it's very important. We elect these people to office, and whether you voted for or against the person who's currently representing you, it's part of the process that we contact our legislators when we have issues that we want to discuss. Each year, our legislators will pass, each one has about 20 bills per year, and you multiply that. You can, if you do the quick math, you'll find that we have, yes, about 2,000 bills a year, almost 2,500 this year, including the resolutions, 2,472, but you know, who's counting this particular session. And each one of these will follow a path that looks something like what's on the screen here, and it's going to go through to both houses, and it can fail at any point, the committee hearing or the floor. And so we're going to go look individually at each part of this path and move rather quickly so we can get to some of the bills that are going on. The introduction of a bill starts with an idea. And that may be an idea that the lawmaker comes up with him or herself. A constituent may come forward with an idea for a piece of legislation, or an organization. In California, we find that a lot of the abortion-related legislation that amounts to, of course, an expansion of abortion in our state is actually sponsored by Planned Parenthood or NARAL or a similar organization. And then they will draft the legislation, and they'll find an author to carry it for them. This can be both on good and bad legislation, obviously, but this is the way it occurs a lot of the time. And either that draft bill will be able to be submitted, or the Legislative Council will make sure that the proper code sections are addressed in the piece of legislation. And once that's been done, the author will introduce the legislation by what's called its first reading. After that, the legislation will go to the Rules Committee for assignment. The Rules Committee, pretty powerful, will determine which of the policy committees are going to be hearing the bill. There may be just one, there may be two. We call that a double referral. And one really concerning thing that happened just earlier this week, in fact, on Monday, that in the Senate, there was an action to remove transparency in that House. Usually when a bill is introduced, it has 30 days to kind of cure. So people, like any policymaker, any individual, can look at it, start getting an idea of what the bill is all about, get an idea, some strategy. Well, that was changed to 72 hours. That's not much transparency now in the state of California, at least in the Senate. This has not occurred yet in the Assembly. When the bill gets to the policy committee, the supporters and opponents will strategize. How are we going to support this bill? How are we going to get it to pass? Or what can we do to hold this back? Individuals and organizations can submit letters of support or opposition to the committee itself. And this is when you see this golden arrow here, this is where you can share your views. Of course, you can do that anytime, but this is a key point at a policy committee point where you can share your views with letters, webmail, or phone calls. And one thing that COVID actually did for us is made the committee hearing process a little bit more transparent and friendly for individuals like you and me, to be able to take part in the hearing. And you can submit your letters through, this is a picture of the State Assembly Health Committee website. You can submit your letters directly to the committee. There's a one-time registration. You pick a username and a password, and it's good from now on. And you can submit a position letter rather, in the form of a PDF document directly to the committee. And those are actually visible to legislators as they look at it. And the committee will then, they will note the number of letters from individuals. They will list on the analysis of the bill the letters that come from organizations, your pro-life organizations. Very important that letters get in. So those would be visible. And this is what it looks like when you go to that portal. You would be signing in with an email and password, and then uploading your document. Pick up the measure that you want to support or oppose it, and submit a letter. It's a lot simpler than it sounds, and it's really great that we are able to take part in that process. At the policy committee hearing, there will be testimony from both sides. It's limited to 2 speakers on each side, 3 minutes each, and then there's discussion. And one of the things we like our legislators to do, especially on our pro-abortion bills, where usually we're on the defensive in the life situation, is the discussion allows anyone on the committee who is in the minority, in this case usually, to be able to ask questions and get more information. Anytime that we can get the truth put in the record, the truth about life, it's a good thing. And now, because of COVID, oddly enough, we can actually provide from our homes, from our desktops, from our kitchen tables, what's called a Me Too. Yes, that's you. You can be a Me Too at a committee hearing. And that just means that when you listen or watch a hearing, you're going to be able to, this is the health committee again. This happens, this is what you will see. This happens to be the Senate Education Committee. I wanted to show it to you because when you're watching the hearing, you're going to see a participant call-in number and an access code, and you can actually take part. It's a long wait. Be ready with some, popcorn and soda or something, or whatever's going to keep you going for a little while, because committee hearings can be long. I'm sure John can attest to that. But you are then at one point, after the discussion, there will be an opportunity for anyone who is listening and part of the phone call and who is registered in the phone call to say, my name is Penny Harrington. I'm from the San Diego area and I oppose this bill. That's all you can say, but you can actually get your name in the record and take part in the process. At the outcome of the policy committee hearing, the bill will pass, the bill will fail, or it could be reconsidered, where it might be able to come back. If it passes, it will move perhaps to another policy committee, or it will move, if it has a fiscal component, to the appropriations committee. If it doesn't, it will make its path to the floor. Any bill that has a fiscal component that's going to cost some money to the state will have to go through the appropriations committee in the house that it's in. And after that committee, it will pass either to the floor, or it may fail, or if it does have a considerable amount of funding needed, it will be placed in suspense until the budget revision comes out in May. And often it will go, even if there is a monetary component to a bill, I think the amount is about $50,000. If it's less than that, it will often just get passed out to the floor, because that's small change in terms of our fiscal committee process. Another time that you get a chance to share your views is on the floor. Very important that you contact your member of the Assembly or the Senate when a key bill is on the floor. Contact them, call their office. Phone calls are great. Keep the phones ringing off the hook. You can also contact them through webmail. If you're in their district office, you can go in and speak with people there. It's just great to take part in the process and let them know. Even if they don't agree with you, they need to hear what you have to say. And so there will be a second reading. And then a couple of days after that, there will be a third reading, and that's when the floor vote occurs. And there's generally discussion before the vote takes place. And that's another time that the truth can be spoken into the record. So you can get your assembly member or senator to ask questions or speak out for or against a bill on the floor. If it passes, it will go through the process in the second house. If it fails, it's dead. But an author can also, if he or she doesn't feel like he has enough votes, can also place it on an inactive file to be brought back at a later date. Second verse, same as the first. It goes through the second house again now. We've been all the way through the first house, and now we're going through the second. And it's basically the same process. Again, make your views heard in the policy committee at the floor vote. If it passes the second house and it was amended, it will have to go back for a concurrence vote in the first house. If it doesn't, then it will end up being enrolled and going to the governor. If it fails, it's gone. Those bills that were in the inactive file in a year like this is the first year of a 2-year session. It may actually be held over if the author doesn't think he or she has the votes to make it happen, or maybe the governor's saying, I don't know about that. You can hold it over for the next year, but that's just in the first year of a 2-year session. And that's where we are right now. We're in the first year of a 2-year session. When the governor gets the bill, he has 12 days to make a decision on it, or since most bills come at the end of the session to his office, at that point, he has 30 days to either sign the bill, veto the bill, or if he does nothing, it will become law without his signature after 30 days. So when you contact the governor, in a lot of these cases, the key word is veto. You can't just depend on the fact that he might not sign it. It will become law in California without his signature if he does not veto a bill. So you'll want to share your views with the governor on whether you want him to sign or veto a bill when we get to that point. The final step after that, if he has signed it, is enrollment and chaptering. Most of the laws in California take place January 1st of the next year, or if it's an urgency measure, it will take place after it's signed by the governor. There are various deadlines throughout the year in California. This is just a picture of the legislative calendar. When you go to the website of one of the houses, you can get a copy of the deadlines and the policy deadlines that are important. For example, we just passed the February 19th bill introduction deadline. We will have a policy committee deadline on April 30th for bills that have money attached to them. May 7th is the non-fiscal bill deadline, and then all bills have to be out of their house of origin by June 4th. Then we come back and the second half of the session continues. July 14th is the policy deadline for the second house. They get to go on recess from July 16th to August 16th. That's a great time to visit your legislator in their district office. The last day to pass any bills this year is September 10th, and there's that 30 days for the governor to act on a piece of legislation before October 10th when it's all over. A few other procedures, amendments can be done during the committee process, on the floor process even. And a lot of bills right now that were introduced in that 2,500 bills or so are what we call spot or intent bills. They just have a little bit of language in them that says it's the author's desire to provide change in language in this particular code area. Well, that official language will then be dumped in over the next week or two as an amendment, and then we'll find out what some of these bills are. So we don't really know what all the bills in California are about just yet, because there will be amendments coming up. And then there's the gut and amend. John wanted me to be sure to tell you about this interesting little end run. The gut and amend process is sometimes a legislator will use a little sleight of hand to move a languishing measure forward. And famously in 2012, Christine Kehoe took an abortion bill of hers that had failed, and it was to expand a pilot project in Northern California to allow nurse practitioners and other clinicians to provide aspirations or perform aspiration abortions. Well, she wasn't getting anywhere with that bill. It had passed the Public Safety Committee, but failed in the Business and Professions Committee. But rather than accept defeat, she decided to extend the pilot program and pulled a fast one. She took one of her other bills that was languishing. It was actually a 2-year bill at that time. It was about amounts of copper in marine paint or something, nothing to do with the life issue, but she gutted it and dumped the language for her abortion expansion bill into it, and it passed voila, the gut and amend. So that's the procedure that can sometimes happen. On a 2-year bill, the bills that don't make it through, as I mentioned, the entire process will be put on hold, and then they have to speed through the process early in the following year in most cases. Keep an idea, maybe jot down some of these websites. The Assembly website, simply assembly.ca.gov. The Senate, the same, senate.ca.gov. The governor, you're going to want to be able to contact him. It's great. There's a contact tab on his website at gov.ca.gov. And if you really want to track legislation, you can actually subscribe to a bill that you're interested in by going to this leginfo.legislature.ca.gov, look up the bill number and subscribe to it, and you'll get an email every time there's a change to the bill. So let's look at a few of the bills that are up this year. There are about 3 bills and 1 resolution that I want to quickly go over with you, and you might want to jot down the numbers of these bills so you can subscribe to them and keep track. Assemblywoman Sydney Kamliger from Culver City has introduced the PEACE Act. Where would we be without acronyms, right? Protecting Equal Access to Care Everywhere Act. Well, it sounds great, doesn't it? Equal care everywhere. But what she's actually done is she is pointing at Catholic hospitals and saying not enough is being done at Catholic hospitals or faith-based medical institutions because they place restrictions on the procedures that can be done there based on their religious beliefs. This cannot stand, says the Assemblywoman. So it's important, this might be an important bill that you would want to track this year. She says in her fact sheet for the PEACE Act that some of the procedures that are being prohibited in their facilities are reproductive care, access to contraception, surrogacy, assisted reproduction, and other items that are contrary to their religious teachings. So this is really a direct attack on faith-based hospitals, forcing them to comply. There is not a committee assignment on this bill yet, but it will probably go to the Assembly Health Committee and likely the Business and Professions Committee. I'm guessing that it will probably be a double referral for AB 705. SB 245 is the Abortion Accessibility Act. Now, we all know that abortion is highly accessible in California already. And you might wonder, well, what in the world could they possibly do to make abortion more accessible? I mean, to go back to Dr. New's comment about the age of minors being able to have abortions without their parents' consent, in California, that's 7th grade. That's our school's ability to let students out for confidential medical services without the parents' knowledge even. So a 12-year-old girl can go get an abortion without her parents even knowing about it. Now, so what more could they ask for? Well, the Abortion Accessibility Act prohibits insurance companies from charging copays, requiring satisfaction of deductibles, or requiring any other payments for abortion services. So we're already paying out of our tax dollars for Medi-Cal abortions, and now insurance companies are going to be required to make all abortions, every dollar of an abortion, free. And I was taking notes when Dr. New was talking, and he said the more taxpayer funding, the more abortions. Well, the freer the abortion, we can expect that the more abortions that we're probably going to have as a result of this bill. It's been assigned to the Senate Committee on Health. And right here, you can see the members of the committee. There are 2 members in this committee who are Republican members. The other 9 are Democrat. When you have a supermajority, that follows through to the committee process. Some committees only have 1 Republican member. So here is the Health Committee. There's no hearing date on this bill yet, but there again, there's the submit position letter link for you to be able to submit a letter. The 2 Republican members are Senators Melissa Melendez and Shannon Grove. if there are ever a couple outspoken women in the Senate, those two are likely to ask a lot of good questions of the senator when she brings this up. They're very staunchly pro-life. SB 380, this is the last of the policy bills, and then there's just a quick resolution. I'm almost done. SB 380 has to do with the end of life. We're on the other spectrum of life here. Senator Susan Eggman of Stockton has proposed this. Many of us remember that the End of Life Option Act was passed in 2016. And we were all concerned at that point that there was a slippery slope to physician-assisted suicide, and it was only going to get worse in our state. And here we go. SB 380 will remove the sunset clause in the End of Life Act. So it was supposed to sunset in 2026. This removes that, it repeals it entirely. And so we will have assisted suicide until it's repealed in some other way. It also lowers the bar for the mental health exam, which there's not even a mental health exam required before a physician prescribes and the pills, the prescription for someone to end his or her life. But if the physician says that a mental health examination is warranted, it lowers the bar to where a clinical social worker can provide that mental health examination, not just a psychiatrist or a psychologist. It also does some other things. It removes the requirement of timing for the oral request for the drugs. A physician has to, if he or she does not want to participate in the end of life care, so to speak, because they took an oath that said first do no harm, they have to refer to a doctor who will. Sounds a little bit like the NIFLA decision, and I'm wondering if that might come into play. Getting a little nod from John over there, I think that, so we will see what happens with SB 380. Again, it was referred to the Health Committee, not a hearing date on this, so the same players in that committee. Finally, every year there are 2 resolutions celebrating Roe v. Wade. The Assembly has already passed theirs. It was H.R. 10. SR 6 is the Senate version. Nancy Skinner has brought this up, but everybody else who is pro-abortion is jumping on as a co-author. And this has been assigned to the Judiciary Committee, but I would say at this point, just go ahead and call your state senator and ask him or her to oppose the resolution. Again, I would suggest if you're interested in any of these measures or others that you subscribe to them and track their progress. You'll get an email. And then my charge to you is that a couple of things. First of all, not a lot is going to change in California until the complexion of the makeup of the legislature changes. So let's keep that in mind in the next election year that we have, that we might have a more pro-life legislature in California. And then also our tasks individually are to learn, like we are tonight, about the process here and elsewhere, to pray, because this is a battle that's bigger than flesh and blood. It's powers and principalities, and it's the creation of life that that we don't have control over. God does at the beginning and at the end. And then it's up to us to act. So we learn, pray, and act and participate in the process. Dietrich Bonhoeffer said the ultimate test of a moral society is the kind of world that it leaves to its children. So let's determine that we're going to leave our children and grandchildren a world and a moral world that respects life. So thanks very much. Learn, pray, and act.
Wonderful. Penny, thank you so much. That's such a great and needed explanation of how the California legislative process works. And yeah, some truly alarming bills that definitely we at Right to Life of Central California will be on top of to inform all of you about as the year goes along. I'm not seeing a ton of new questions in the chat, but certainly we deeply appreciate Penny for her work. Penny does this work of monitoring thousands and thousands of pieces of legislation every year for a bunch of allied organizations, Right to Life, Central California, California Family Council, and a bunch of others, and does it out of the goodness and kindness of her heart. So we so deeply appreciate you, Penny, for your work. And yeah, as you say, learn, pray, and act. All right. Well, folks, I think that about does it for our presentation this evening. This event, if you enjoyed this event, if you thought this was valuable, do get in touch with us over the next few days. Let us know to echo what Professor New and Penny said: learn, pray, act, be involved with the political process. Stay tuned to Right to Life of Central California for more publications and work. If you want to get the audio of today's presentation, you can get that from our podcast stream. Just look for Right to Life Radio on Apple Podcasts or Stitcher. You can also watch this presentation after the fact on YouTube. So get it and share it. And I think that about does it for us. So on behalf of all of us at Right to Life of Central California, thank you all so much. And I hope this was valuable to you. I hope you'll be able to share this with your friends and family after the fact. So thank you all, Raphael, unless there are any further questions. And I think that's it. So thank you all so much, and God bless.